The brokerage operations. The broker's office. Every broker has to have an office somewhere, and it doesn't have to be in the state of Florida. By definition, an office is at least one enclosed room of stationary construction where negotiations take place and records are kept. And every registered office, the registration is valid for 2 years. The official sign. Every broker has to have an official sign on or about the entrance of their office. And on that sign has to be the name of the brokerage entity if they're doing business as a brokerage entity. It's got to have at least one broker of record. There could be more than that if there are more than one brokers. And it's got to have the words licensed real estate broker. You could also include sales associates' names on that sign, but just remember that they have to be segregated separately from the broker with their license status posted as well. A branch office. A branch office is any subsequent office to the broker's main office. That branch office has to be registered. But remember that a branch office is not transferable. A temporary shelter does not have to be registered as a branch office. You have to look at the purpose of the building to determine whether it's a temporary shelter or a branch office. Advertising. Advertising is a service of real estate, and every advertisement is the full responsibility of the broker. Advertising could include newspapers, magazines, business cards, calendars, and even refrigerator magnets. All advertisement has to contain the name of the brokerage entity. Otherwise, that's considered to be a blind advertisement, and that is illegal. Telephone solicitation. There are 2 do not call lists that are on the market right now. One is the state of Florida. The other is the federal government. If a person registers their telephone number with the Florida Department of Agriculture and Consumer Services on the do not call list, we're not supposed to be able to call them. The only exception might be that if we've done actual business with them over the last 18 months. Also, if a for sale by owner runs an ad with their telephone number in it, they can no longer hide behind the protection of the do not call list. As far as the federal do not call list is concerned, it doesn't matter if they're for sale by owners or not. We are still prohibited from calling them unless we've done business with them over the last 90 days. Escrow accounts. Brokers are not required to have an escrow account, but if the broker does choose to hold escrow, there's 2 ways that they can do it. One is signature, the other is non-signature. And it's important to understand that any escrow account that a broker has, that facility has to be doing business in the state of Florida. It can be held in a commercial bank, a savings and loan association, or a credit union. The broker is always signature on those accounts. The accounts that the broker is non-signature would be title companies and placing them with attorneys with trust powers. Types of deposits that a broker can collect. Brokers can collect cash, checks, that's both personal and business, stocks, bonds, promissory notes, and post-dated checks. A quick comment about promissory notes and post-dated checks. Before those can be accepted, the broker has to get permission from the seller first. Interest on the escrow account. If the broker is the signature on an escrow account, they can place that money in either a non-interest-bearing account or an interest-bearing account. If they choose an interest-bearing account, the interest on that money earned can be sent anywhere that the buyer and seller chooses. Remember that even the broker can collect the interest provided that the buyer and seller agree to it at the time the contract is entered into. Timely escrow deposits. Earnest money has to be deposited in escrow immediately. For sales associate, that means the next business day. For brokers, it has to be delivered in escrow within 3 business days of the date that the money was actually tendered, which means that the time that the sales associate picked it up, it has to be delivered within 3 business days into escrow. And until the contract is formed, remember that the money is under the control of the buyer. Escrow account disputes. When the broker is the signature on the escrow account and has either conflicting demands or good faith doubt, that broker has to notify the Florida Real Estate Commission within 15 business days of that demand. If the dispute has not been resolved within 30 business days, the broker is going to have to take one of 4 settlement procedures. Settlement procedures. Mediation is where a third party helps resolve the issue. Remember that mediation is a non-binding situation. The escrow disbursement order is where the broker asks the Florida Real Estate Commission to give them direction. Once the Real Estate Commission does tell them what to do with the deposit, it's binding to the broker. Other settlement procedures. Buyers and sellers can always go to litigation and ask that a judge interplead. They'll be asking for a declaratory judgment as to the disposition of the deposit. Also, there's arbitration. Arbitration is when a third party makes the decision for the buyer or seller. This is binding to the parties. Further FREC notification. If the dispute has been resolved, no matter what the issue is, the broker is required to notify the Florida Real Estate Commission within 10 days of the resolution.